I'm reading Restrictions on Marketing Practices out of the Reference Guide to Regulatory Compliance. This is on paper page 923 of the old text. It includes the Telephone Consumer Protection Act, restrictions on telemarketing, telephone solicitation, and facsimile advertising. It includes the Telemarketing and Consumer Fraud and Abuse Prevention Act, as well as the FTC Telemarketing Sales Rule, I guess as implemented by the FTC Telemarketing Sales Rule. This is also including controlling the CAN-SPAM Act, which actually stands for Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003, FTC CAN-SPAM Rule, perhaps is implementing the CAN-SPAM Act, and the Junk Fax Prevention Act of 2005. Over the years, Congress has received numerous consumer complaints regarding marketing practices. These practices involve unsolicited faxes, telemarketing, phone calls, and emails. Congress is concerned with rising consumer fraud associated with these practices. Legislative solutions included the Telephone Consumer Protection Act of 1991, Telemarketing and Consumer Fraud and Abuse Prevention Act enacting in 1995, the Junk Fax Prevention Act of 2005, and the CAN-SPAM Act of 2003. Certainly not in order. Both the Federal Trade Commission and the Federal Communications Commission have jurisdiction over telemarketing practices. The FCC issued its restriction on telemarketing, telephone solicitation, and facsimile advertising rules to implement the Telephone Consumer Protection Act. These rules apply to banking institutions as well as other businesses. The FTC Telemarketing Sales Rule was finalized in March of 2003. This rule prohibited certain telemarketing practices and provided customers a right of privacy from unwanted telephone calls. These regulations implemented a system whereby consumers could list their telephone numbers in a national registry of telephone numbers that would be protected from unsolicited telemarketing calls. Telemarketers were required to purchase the list and keep their files updated so the numbers on the list would not be called. I love how it says telemarketers were required to. It's because this is hardly ever abided by telemarketers that it probably is written in that way. The rules also regulate abandoned calls and require certain disclosures during telemarketing calls. Although banks are subject to the requirements of the Telephone Consumer Protection Act, they are not governed by the FCC Telemarketing Sales Rule. However, telemarketing companies hired by banks are governed by it. The Controlling and Assault of Non-Solicited Pornography and Marketing Act of 2003, CAN-SPAM, was enacted to regulate email marketing and thereby control spam. The law became effective in 2001 and 2004, January 1 of 2004. The FCC issued regulations to implement the law. While the FCC does not regulate financial institutions, the law gave authority to other banking regulatory agencies to enforce the regulation of banks and other financial institutions. The CAN-SPAM Act covers commercial email messages. It requires the message to have a clear, non-deceptive subject line and to include certain disclosures. The Junk Fax Prevention Act of 2005 was a congressional response to the proliferation of unsolicited marketing via facsimile transmissions. The first law to control this form of marketing was the Telephone Consumer Protection Act of 1991. The TCPA prohibited unsolicited faxes for marketing purposes and had no exemption for established business relationships. The Junk Fax Prevention Act provided for an exemption for persons with whom the sender has an established business relationship and requires an opt-out mechanism. The FCC rules that implement this law became effective in July of 2006. Subsection 1, FCC Telemarketing Rule, Restrictions on Telemarketing, Telephone Solicitation, and Facsimile Advertising. Implements the Telephone Consumer Protection Act. The coverage is all entities including financial institutions. The requirements are 1. may not initiate pre-recorded telephone calls or calls using automated telephone dialing system to emergency numbers, police or fire department numbers, hospital patient rooms, healthcare facilities, elderly homes, or mobile phone or pager numbers. 2. May not initiate pre-recorded telephone call or telephone calls using artificial voices to residential telephone numbers without the express consent of the called party, unless the call is made for emergency purposes, the call is not made for commercial purposes, the call is made for commercial purposes but does not include an unsolicited advertisement, or the call is made to a person to whom the caller has an established business relationship. This means a prior or existing relationship before the caller and the recipient based upon a voluntary two-way communication between the parties, whereby the customer entered into a purchase or transaction with the caller within the past 18 months and which relationship has not been terminated. A request to be placed on the do not call list is considered a termination of the relationship. E. The call is made by a tax-exempt nonprofit organization. 3. May not issue an automatic dialing machine so that two lines of a multi-line phone are in use at the same time. 4. May not abandon more than 3% of the calls made by any one person within a 30-day time period. A call is considered abandoned if a live salesperson is not connected within 2 seconds of the called person's completed greeting. A. If a salesperson cannot be connected within 2 seconds, a telemarketer must deliver a pre-recorded identification message that identifies only the name and telephone number of the business and states that the call was for telemarketing purposes. B. The message must disclose a telephone number for the seller, and this number must be available for the recipient's request to be placed on the seller's do not call list. Number 5, may not connect an unanswered telemarketing call before 15 seconds or 4 rings. And 6, may not use any technology to dial phone numbers for the purpose of determining whether the line is a fax line. 7, all artificial or pre-recorded calls must state the name of the responsible business at the beginning of the call, state the telephone number during the message, it may not be a 900 number, and provide the telephone number that must be the one the recipient may use to be placed on the do not call list. 8, no person may initiate a call to a residence before 8 a.m. or after 9 p.m. 9, no person may initiate a call to a residential telephone subscriber whose number is registered on the do not call list. Registrations must be honored indefinitely unless the request is canceled by the consumer or the telephone number is removed by the database administrator. Calls to such telephone numbers will be considered violations of this rule if the business has implemented written procedures to comply with the do not call rules, trained its personnel, maintained a list of do not call telephone numbers, developed a process to access the do not call database, and updates the list every 31 days. And lastly, establish a process to ensure that it does not use the do not call database for any purpose except to comply with this rule. If the caller obtains the recipient's express consent shown by a signed written agreement. And see if the caller has a personal relationship with the recipient. 10, telemarketers must maintain an internal do not call list and may not make telephone calls to a residential number unless the list is maintained. The telemarketer must have written policy for maintaining the internal list, train its personnel for the use of the list, and C, place all names and numbers on the list within a reasonable period of time, not to exceed 30 days, when asked by a telephone subscriber, unless otherwise requested. A subscriber's request to be placed on the do not call list will apply only to the business making the call, not to its affiliates. D, require individuals making calls for telemarketing purposes to provide their names, the names of the business, and telephone number of the business. And E, honor all do not call requests for 5 years. Participants, penalties up to $500 per violation are available. FTC telemarketing rules implements the Telemarketing Consumer Fraud and Abuse Act.